All right, good morning, everyone. We are here for the Pro Bono Partnership of Atlanta's presentation on the new overtime regulations. Now what? My name is Scott Mario. I'm an attorney and the employment team at King & Spalding here in Atlanta, and I'll be giving the presentation this morning. Before we get started, I wanted to remind everyone the mission of the Pro Bono Partnership of Atlanta is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. For anyone out there who is not already a client of the Pro Bono Partnership, if you look at the slide that's in front of you now, or will be very shortly, there are the eligibility requirements for becoming a client of the Pro Bono Partnership, and you can find more information on our website at www.pbpatl.org. So if we can turn to slide number 5, we'll get started. A quick overview of our agenda this morning. We'll start out with talking about the basics of the FLSA overtime requirements. Then we'll talk about the new overtime rules that you've all heard so much about and what you can expect going forward. We'll discuss the ins and outs of reclassifying employees from exempt status to non-exempt status. And we'll cover the basic rules for how to compensate non-exempt employees. And then we'll wrap up with a discussion of alternative types of labor, such as independent contractors, volunteers, and interns. And time permitting, we'll be glad to take your questions at the end of the presentation. So, the Fair Labor Standards Act, quick history lesson for you. The FLSA was passed during the Great Depression. And as you can see here from the slide, there are 3 basic components to the FLSA. There is a child labor component, a minimum wage component, and an overtime component. And we will be focusing this morning on the overtime component. Now, many people think that the FLSA was passed to protect workers, and that's true to a certain extent. But the main reason that the overtime component of the FLSA was adopted was to create jobs. So if you think about it, the FLSA was passed during the Great Depression. This was a period of time when millions of folks were unemployed and there were breadlines, and Congress was struggling with ways to spur hiring. So before the FLSA, if you were an employer and let's say you had a job that would take 80 hours per week to do, it didn't matter whether you had one employee doing that job who was working 80 hours per week or whether you had 2 employees doing that job, each working 40 hours per week. But with the enactment of the FLSA and the overtime requirement in particular, it was more expensive for an employer to have that single employee work 80 hours a week than it would be to go hire a second employee to take on the additional 40 hours a week and not have to pay overtime. So we can move on to the next slide now. The basic overtime requirements. There's 2 basic overtime requirements here. This is slide number 7. The first is that the employer must pay overtime wages at the rate of time and a half, 1.5 times the employee's regular hourly rate for all hours worked in excess of 40 hours in a work week. And the second requirement is that the employer must keep accurate records of all time that the employee works, because that's how you know as an employer, and it's how the DOL knows when they audit you, exactly how much money that employee is owed. All right, the next slide. A word about terminology, exempt and non-exempt. So when we say an employee is exempt, we simply mean that the employee is covered by an exception, or to use the legal term, an exemption from the FLSA's minimum wage and or overtime requirements. Now, you'll note that I did not use the words salaried and hourly. Even though people often use the term salaried and hourly to refer to exempt and non-exempt employees, these words don't mean the same thing. And in fact, as we'll see later on this morning, it is possible for an employee to be both salaried and non-exempt. Another thing you'll note about the terms that we're using here, exempt and non-exempt, is the default rule is an employee is not exempt. That is, the overtime requirements apply to the employee. To be exempt, an employee must fit within one or more specific exemptions that Congress has created. Now, the most common ones, the ones that you may be familiar with in the nonprofit world, are the executive, administrative, and the professional exemptions, and these were the exemptions that were impacted by the changes to the new FLSA regulations that we'll be discussing this morning. So it's not enough to just pay an employee a salary to have them be exempt. They have to also fit within one of the exemptions. All right, next slide. So apart from the three most common exemptions that you're familiar with, there are a host of other exemptions that Congress has created over the years, and I've listed on the slide here a few of my favorites. So the first one, there's a special exemption for employees who catch or harvest fish or shellfish, crustaceans, sponges, or seaweeds. Not sure if that will apply to anyone that's listening in this morning, but perhaps you can take advantage of it if you do. Movie theater employees also exempt. So think about it. You go to the movie theater, the 16-year-old kid who's taking your ticket is an exempt employee. And then lastly, a little something for Christmas. Home workers who make wreaths are exempt, but only if the wreath is made of holly, pine, cedar, or another evergreen. So no plastic wreaths. That wouldn't be exempt. All right, so moving on to the next slide. Three basic requirements to be exempt: the duties test, the salary test, and the salary basis test, and the salary level test. And all three of these requirements must be met for an employee to be exempt. So the duties test is what I just mentioned. The employee has to perform duties that fall within one of the specific exemptions enumerated by Congress in the FLSA. The salary basis test means just what it sounds like. The employee must be paid on a salary basis as opposed to on some other basis like hourly pay. And the salary level test, the employee must be paid at a level of compensation that is at or above the minimum salary level set for the exemption. And that is the piece of the overtime rule, the salary level test, that was impacted by the FLSA changes that are making headlines over the last few months. And that's what we'll get into shortly. So with that, let's go to the next slide, the new FLSA regulations. As you probably know, we're supposed to take effect on December 1st, just a couple weeks ago. And what they would have done, and what they may do if they end up becoming effective, is they would actually double that minimum salary level under the salary level test from the current level of $23,660 per year to $47,476 per year. And in addition, this minimum salary level would adjust automatically every 3 years. The idea basically being to keep pace with inflation and cost of living increases and so forth, which currently it does not do. In fact, the salary threshold has only been changed one time since 1975. And the last time it was changed was back in 2004. So there's pretty broad consensus, although not everyone agrees how much the salary level should be increased, but there's pretty broad consensus that there should be some increase. The question really is, and probably will be going forward, how much of an increase there should be, and should it all take place at one time, or should it be phased in over some gradual period? All right, so moving on to the next slide. So what happened? Well, what happened is a group of states got together, and a separate lawsuit was filed by a group of businesses and business stakeholders, business groups, and they sued to block the new regulations from going into effect. Now, those of us that practice employment law and watch these things very closely thought there was essentially no chance that this was going to go anywhere. Well, we all got a surprise, the second surprise of the year, I guess, after the election. On November 22nd, 2016, the judge who was hearing these two lawsuits, which were consolidated in federal court in Texas, actually granted a preliminary injunction blocking the new FLSA regulations from taking effect, at least on a temporary basis. And so the slide here shows the judge. This is actually the judge that issued this order. His name is Judge Amos Mazant, and he is a federal district court judge in Texas. A bit unexpected. He's not sort of one of these far-right conservative judges that may be prone to issuing rulings that are a little out of step with the mainstream is actually appointed by President Obama just a couple of years ago. But in any event, Judge Mazant held that the DOL overstepped its authority by doubling the minimum salary level. And without getting into too much detail, it's a rather controversial decision, and the Department of Labor immediately appealed to the Fifth Circuit. So we go to the next slide. We'll see what happens next. Well, there's a few different possibilities. So as I said, at this point, the DOL, the Department of Labor, took an immediate appeal from the judge's decision to the Fifth Circuit Court of Appeals, which is the intermediate court of appeals between the District Court and the U.S. Supreme Court. And that's a generally conservative court. It has agreed to expedite the DOL's appeal, because usually this could take several months, if not a year, to decide. However, even with the expedited briefing schedule that the court has set, the case is not going to be decided before January 20th, when Donald Trump is sworn in as president. So the next possibility is that, depending on how things shake out in the Fifth Circuit, the case could wind up in the Supreme Court. And that's assuming that the Trump administration continues to prosecute the Department of Labor's appeal. Then whichever side loses at the Fifth Circuit would likely appeal to the U.S. Supreme Court. Well, there's no guarantee that the Supreme Court would take the case. And even if it did, it's anyone's guess as to how the court would rule, because ever since Justice Scalia passed away, there's been a vacancy. And that has resulted in the court being more or less ideologically divided evenly. So who knows what the Supreme Court would do with this. The other possibility is that there could be some action taken by Congress. So before the presidential election in November, there were multiple bills that were introduced in both houses that would have either stopped or delayed or modified in some fashion the new overtime rule. And there really wasn't much momentum for those bills, because if you think about it, prior to November 9th, most people, including most people in Congress, did not expect Donald Trump to win the election. So the thought was, what good would it do to spend all this time getting these bills passed when they knew that President Obama, who after all was the one who directed the DOL to pass these rules, would simply veto whatever legislation was passed, and Hillary Clinton would do the same thing. Well, that's all changed now, of course. So with a Trump administration, we expect that there will be a lot more support for passing some legislation that would pare back the regulations or change the effective date of the rule. The other thing that could happen as a result of a new Trump administration is that the Trump administration itself could take some action apart from whatever Congress does. So Donald Trump, although the new overtime rule did not come up a lot on a campaign trail, did make comments suggesting that he would be open to paring it back or to delaying the implementation. And in fact, his new nominee for Labor Secretary, who he just announced a few days ago, a gentleman named Andrew Puzder, he is the CEO of the company that runs Carl's Jr. and Hardee's fast food restaurants. He is no fan of the FLSA regulations, or frankly, a lot of other regulations, and he has made that known. And so it's entirely possible that either the Department of Labor under Mr. Puzder will simply abandon its effort to appeal the lawsuit, which would mean that they lose by default and the current rules stay in effect, and or they could take some additional action to pull back the new regulations and modify them, perhaps along the lines of what Mr. Trump had suggested, either delaying implementation, providing for a gradual phase-in, or even creating a special exception for small businesses. So that's sort of where we're at right now, and no one really knows exactly what's going to happen. So what should you do now? Let's go to the next slide. Three basic options in front of you. You can either wait until the dust settles and we know whether and when the new rules will be implemented. You could go ahead and raise employee salaries if you can afford it, so that they are at or above the new minimum salary level specified in the new regulations, and that way you can preserve their status as exempt. Or you can go ahead and reclassify exempt employees and make them non-exempt. in anticipation of the new changes. Well, what if you've already made changes in the expectation that the rule would become effective on December 1st? Now, I can speak as a attorney in private practice. I have a number of clients who are in exactly this position. They spent months and months planning and preparing for the regulations to take effect, and they had already announced, and in many cases had actually rolled out changes prior to December 1st because they wanted to time it with their payroll periods. And then a few days before the effective date of the rules, along comes Judge Mazant and issues this order. Well, if you've already made the changes and you can afford to keep the employees, if you've raised their salaries, let's say, and you can afford that, then it would be wise to keep those changes in place. Simply from an employee morale standpoint, it would be very difficult to go tell an employee who's just been given a raise right before the holidays that, never mind, we're going to take your raise back. If you have reclassified employees from exempt to non-exempt in anticipation of the DOL's rule changes, then the choice is not so simple. So think about it this way. Some of the employees that you reclassified probably did not qualify for an exemption because they're not performing exempt job duties. They don't fit within one of the exemptions specified by Congress based on the duties they're performing. So for those employees, it doesn't matter whether the minimum salary level is $23,000 a year or $47,000 a year. They're not going to qualify for exempt status either way. So with respect to those employees, you should leave them reclassified as non-exempt. You should not put them back into exempt positions. For other employees, you may have to engage in a more nuanced analysis, because if you have an employee who could qualify for exempt status based on the job duties, but you have had to reclassify that person because of the minimum salary threshold, maybe it makes sense from an operational standpoint to move that person back to being an exempt employee. But again, that's a business decision that you'll have to take into consideration, and you also have to consider how you will communicate that message to employees who are likely to be very confused and anxious about what's going on and what's happening to their pay and benefits. Okay, so the next slide, slide 15. Option number one was wait until the dust settles. So let's assume that you haven't made any changes, right? So this is one situation in which it actually pays to procrastinate. You haven't done anything. Don't do anything now. Let's wait and see what happens. We know the new rule is not currently in effect. It's not likely going to be in effect anytime soon, at least until either the Labor Secretary announces what direction he will take the department in as far as the rule is concerned, or until the Fifth Circuit Court of Appeals rules on the pending appeal. Now, you still want to have a plan in place, and you still want to actually prepare for what will happen if the changes go through, but hold off on actually implementing the changes. You do want to communicate, of course, to employees what's going on. So the slide shows a couple of talking points that you can provide to employees, right? All right, moving on to the next slide. So option number two. You could proceed to raise the salary level of certain employees to the new minimum level, assuming that the rule will go into effect, and that way you can keep those folks classified as exempt. But remember, like we said earlier, there's all three requirements have to be met for an employee to be classified as exempt. They have to satisfy both the salary basis, the salary level, and the duties test. So if you have an employee who does data entry all day long, it doesn't matter whether that employee is paid $20,000 a year or $50,000 a year, the employee is still going to be non-exempt. Next option is to reclassify employees from exempt to non-exempt. The question then becomes, how do you go about setting the compensation for those employees who are moving from exempt to non-exempt status? And there's three basic options that we put up here on the slide. There's a few other options, but these are the three basic ones. The first is to convert them to hourly non-exempt status. The second one is salaried non-exempt status. And the third one is a little bit tricky, and we'll talk about it. It's called the Fluctuating Workweek. So the first option, hourly non-exempt. This works well if you have an employee who reliably works 40 hours per week or less. Let's say the employee works 40 hours a week. You just take the employee's annual base salary and you divide it by 2,080, which is the number of work hours in a year if the employee is working 40 hours per week, 52 weeks per year. That will give you the employee's hourly rate of pay. So in this example, the employee is making $31,200 per year in salary. If you divide that $31,200 by 2080, you get $15 an hour. $15 an hour times 40 hours over a year would be $600 a week, give you the same annual compensation. All right, next slide. So what happens, though, if that same employee works more than 40 hours a week? Well, you have to pay the employee overtime. That's what it means to have a non-exempt employee. So using the numbers from the previous example, if that employee works 45 hours in a given work week instead of 40 hours, the employee will be owed $112.50 in overtime pay, which means that his total compensation for the week will be $712.50. Now, if it turns out that this employee is working more than 40 hours per week on a regular basis, then you may end up owing a lot of overtime. So using these numbers, if the employee is working 45 hours a week instead of 40 hours a week, over the course of a year, that adds up to almost $6,000 of overtime. And if you multiply that by a few employees, you get, well, a lot of money. So that takes us to the third example. You don't have to divide the employee's annual base salary by 2080 to get their hourly rate of pay. That's simply one way to do it. Another way to do it is if you know going into it that an employee works more than 40 hours a week, you can set that employee's hourly rate of pay such that the employee's weekly straight time pay, when combined with the employee's overtime pay, will add up to the same amount of salary that the employee is currently earning on a weekly basis as an exempt employee. And the slide shows the formula for calculating what that number should be. You just take the number of overtime hours per week, you multiply that by 1.5, add that number to 40, and then you divide that amount into the employee's weekly salary. So here the example shows, again, using the same numbers, if the employee is earning $31,200 per week, which is per year, which is $600 per week, it turns out that if you pay that employee $12.63 an hour instead of $15 an hour, that employee will end up earning $600 per week if they're working 45 hours each week instead of 40 hours per week. All right, the next option you have is to make the employee a salaried non-exempt employee. Recall when I said earlier that salaried and exempt don't mean the same thing? Well, here's a perfect example. You can pay an employee on a salaried basis and have that employee be non-exempt. And here's how you do it. You simply agree that you're going to pay the employee their full weekly salary, right, of, in this case, $600 per hour. But if the employee, $600 per week, that'd be quite a raise, $600 per week, but in any week when the employee goes over 40 hours, you will pay that employee overtime. So we have a few examples. If the employee works 36 hours, they get their full salary of $600 per week. If they work 40 hours, they get $600 for that week. If they work 45 hours, you would pay them overtime at time and a half. And here the time and a half rate would be based on $15 an hour, is the base hourly rate. So this option might work well for employees who don't work much overtime. It would, and the key though is that you still do have to pay them overtime, which means you need to keep track of the time they work. All right. Okay. Last but not least, the fluctuating workweek method of paying overtime. And this one is rather complicated, even for attorneys, and employers and attorneys get it wrong all the time. So before you decide that the fluctuating work week sounds like a great idea, I would advise you to consult with an attorney. The concept is that you have an arrangement with the employee where you say, I'm going to pay you a fixed amount of salary for each week. And that amount represents compensation to you for all the hours that you work, whether you work less than 40 hours a week or more than 40 hours a week. And what happens, though, is if the employee does work overtime, that employee will get paid overtime, but instead of getting paid overtime at the rate of time and a half, the employee only gets paid overtime at a half-time rate. And the way that works is the employee's base hourly rate of pay, the regular rate, fluctuates, hence the name, Fluctuating Workweek. It fluctuates depending on the number of hours the employee works every week. So to take an example, let's say the employee's salary is $600 per week, right? And let's say that employee works 32 hours. The employee is going to get paid the full $800 salary, and the employee's effective rate of pay would be calculated by taking 32 hours and dividing it into $800, and you come up with $25 per hour. So keep that number in mind, $25 per hour. Now, let's say the employee works 64 hours, so twice as much. You take the $800 salary, divide that by, instead of 32 hours, divide it by 64 hours. So now the employee's hourly rate goes from $25 an hour to only $12.50 an hour. And the overtime is based on that lower number. So basically, the more hours the employee works, the lower the employee's hourly rate of pay is, which may not be great for morale, but it is legal, and employers do use this method. It is far more cost effective than paying overtime using the time and a half method. But, and I'll reiterate my words of caution, so the next slide, a few requirements. The employee's hours must actually fluctuate from week to week, so this would not be appropriate to use with an employee who works the same schedule week after week after week. It requires a clear mutual understanding, so you ought to have something in writing with the employee explaining exactly how this works. And it can be difficult to administer simply for the reason that you have to recalculate the employee's hourly rate of pay every week because it's going to vary depending on the number of hours the employee works. So that's the piece that a lot of attorneys and a lot of companies manage to screw up on. So the lesson is, don't try it at home. Don't do it by yourself. Get an attorney to help you set this up, or at least an HR consultant who's familiar with this issue before moving forward. All right. So let's move on then to the next slide. Managing the changes. So one way or another, assuming that the new FLSA regulations or some form of the new FLSA regulations take effect in the near future, you're going to have to deal with how you adjust to the changes. How do you manage the changes and the increase in the amount of overtime cost that you'll be facing? So a couple things here, and no, there's no science to this. I mean, the first thing is you want to control the overtime hours that your employees are actually working, which could mean adjusting the work hours to focus on more critical periods and letting employees go home when it's not so critical that someone be there. Flex time, I want to give you a word about flex time. If you have spent any time working for the government, you may be familiar with a concept known as comp time. The basic concept behind comp time is that an employee who works overtime is compensated for the overtime with additional time off in lieu of a cash overtime payment. So it turns out the law does not allow comp time for private sector employers, and that includes nonprofits. Comp time is not the same thing as flex time. Flex time simply means that you send employees home to keep them from going over 40 hours in a single week. So let's say that Lori here stayed late Monday through Thursday, and she's already worked 37 hours for the week by the time she clocks out on Thursday night. So you could have Lori work just 3 hours on Friday and say, take the rest of the day off. That will be an example of flex time. The key is you have to do this each week. In other words, the time that the employee takes off has to be taken in the same week that the hours are worked. And that doesn't line up with a lot of employers' payroll systems that pay on a biweekly or semi-monthly basis. But keep in mind, the FLSA doesn't care about your payroll system. The FLSA looks at hours worked on a week-by-week basis. And if you go over 40, you owe overtime. All right, next slide. So now you're at the point when you've made the decision to switch employees to non-exempt status. How do you go about communicating that decision to your workforce? Well, we have a couple of suggested talking points here on the slide. Key things, two really key categories of things to communicate to your employees. Number one, this is not a demotion. So understand that employees may view the change from exempt to non-exempt status as a demotion. They're used to coming and going as they please. They don't clock in and out. They view themselves as professionals, right? And now all of a sudden, they have to track their time and maybe if not punch a time clock, at least record the number of hours and minutes that they're working each day and when they come and go on their breaks. So it's very important from an employee relations perspective to dispel the idea that the change to non-exempt status is a demotion or somehow a reflection on their skill level or value to the organization. It is simply a change that's being driven by a change in the law, and that's all it is. The other category I would say you should emphasize with employees is that the impact on their pay and benefits at the end of the day should be minimal, right? Because employees are going to have a lot of anxiety about what does this mean for me? I've been paid a salary. I have certain employee benefits that I enjoy. Am I going to take a pay cut as a result of these changes? And hopefully you can demonstrate to the employee that they will not be receiving a pay cut. And in fact, it may help in that regard to have some examples, some sample calculations like we just looked at to show them that if the employee continues working the same number of hours that they work now, they should experience no decrease in their pay or benefits. And when you meet with the employees, I would come prepared with some talking points to answer those questions and to be able to sort of reassure them that aside from the way that the pay is being calculated, they really should not feel a big change in the way that they're compensated on a regular basis. And finally, of course, you have to be prepared to train the employees who are going to be reclassified on how to comply with all these policies that they've never had to comply with before, like tracking their time and so forth. So let's move on then to compensating non-exempt employees. Slide 26. There's four key concepts we're going to be covering in the next few minutes. And they're here on the slide: time worked, breaks, training and meetings, and travel time. Now, there are other rules out there, but we can't cover everything in the time we have here today. However, if you can master these four concepts, you'll be in pretty good shape. So let's start with time worked. This is the central concept behind paying non-exempt employees. The basic principle is this: the employee must be paid for all time worked. And that means, as you might imagine, the time that the employee is actually on the clock at her desk working. It also means that the employee must be paid for other activities that the FLSA considers to be work time. So, for example, traveling from one work location to another work location during the course of your day is considered time worked and has to be paid. Attending work-related trainings and meetings is also considered time worked and must be paid. And lastly, checking email or responding to phone calls outside of the employee's normal working hours is also time worked. So for all those employees who carry mobile devices, like I think everyone does these days, if that employee is checking emails on a Saturday or Sunday and responding to emails and phone calls at night or on weekends outside of the normal work hours, that is considered work time and must be paid. The other concept behind time worked is that an employee must be paid for all time the employee is suffered or permitted to work. And those are the words that are used in the statute. What that means is, even if the time has not been authorized by you as an employer, if you know or have reason to know or encourage or don't discourage employees from working off the clock, you will have to pay the employee, right? So an example would be, I take lunch all the time at my desk. Now, I'm an exempt employee, but let's say I'm a non-exempt employee, and I grab a sandwich, and I use my lunch break to catch up on emails. That would mean that that is work time, even though maybe I'm clocked out, and the employer is not paying me because I'm off the clock. That would be considered work time that must be compensated. Now, if all of this seems confusing, don't feel bad. If you want to go to the next slide, don't feel bad, because even the Department of Labor, which is the agency that's actually charged with enforcing the FLSA, sometimes gets it wrong. So earlier this year, back in August, the DOL reached a settlement in which it agreed to pay $7 million to settle a claim by its own employees that it was not paying them for all the time they worked. All right, let's go to breaks. Now, the FLSA does not require that you give your employees any breaks, but if you do give breaks, and unless you're Attila the Hun, you probably do give your employees some break time, the FLSA says you must follow the FLSA's rules about whether the break can be paid or unpaid. And there's two rules. Number one, breaks of 20 minutes or less must be paid. And the reason for that is simple. If the break is less than 20 minutes, the employee really doesn't have enough time to be truly relieved of their job duties. You're not going to go out for lunch in 20 minutes unless your lunch restaurant is right next door. Number two, breaks of 30 minutes or longer can be unpaid if the employee is completely relieved of duty. So to use my earlier example, if you are sitting at your desk eating a sandwich while checking emails, you are not completely relieved of duty. But if you are, the law says that a break of 30 minutes or longer can be unpaid. So what about breaks that are longer than 20 minutes but shorter than 30 minutes? Well, no one knows. So, training and meetings. Next slide. This one is easy. Training and meetings almost always have to be paid. The only exception would be if you can show that each of the four requirements on this slide has been satisfied. The attendance is outside of the employee's regular working hours. The attendance is voluntary. The training or meeting is not job related. And the employee doesn't perform any productive work during the training or meeting. So unless all four of those factors are met, it's compensable time. Travel time. So when you think about travel time, let's divide it into two parts. First, what is compensable time? Time that must be paid. Well, traveling between job sites during the workday is work time that must be paid. So for example, let's say that you work for Habitat and you visit several build sites during the course of your workday. The time that you spend traveling from one work site to another would be compensable travel time. Traveling to another city for a special one-day assignment is also compensable travel time under the FLSA. So for example, let's say the employee works at your office in Atlanta but has to attend a meeting down in Macon for the day. The time the employee spends traveling from Atlanta to Macon and back to Atlanta is work time. It has to be paid. Overnight travel can be a little tricky. So the rule is that if the travel occurs during the employee's normal work hours, it must be paid. The tricky part is that that rule also applies even if the travel occurs on a day the employee is not scheduled to work. So let's say Lori works from 9 a.m. to 5 p.m. Monday through Friday. If Lori has to go catch a flight on Saturday at 9 a.m., the time that Lori is traveling would be considered travel time, even though it takes place on a Saturday, a day that she is not scheduled to work, simply because it cuts across her regular work hours of 9 a.m. to 5 p.m. So what is not considered compensable travel time? Well, the time that you spend commuting from your house to your office and then back home again at night is not considered compensable travel time. And in fact, in the other examples that we just discussed, you could deduct the amount of the employee's normal commute from the total travel time if it's paid, right? So if it normally takes you 15 minutes to get to and from your office, and you have to go work at another office for a couple of days, that commute time need not be paid. Overnight travel is another example if the travel occurs outside of the employee's normal work hours. So to pick on Lori again, instead of having Lori fly out at 9 a.m., which would fall during her regular work hours, why don't we make her take a plane at midnight and catch the red-eye flight? Well, unfortunately for Lori, that would mean that would not be compensable travel time. Don't really know why the rules are the way they are, but that's what they are. All right, so the next slide. A couple of things the FLSA does not require. As I already mentioned, the FLSA does not require breaks. Also does not require vacation or PTO time. It doesn't require sick leave. It doesn't require holidays. It doesn't require that you give employees extra pay simply for working at night or on a weekend or on holidays. And it doesn't require that you pay employees extra for working more than 8 hours in a day. Now, some states do have state laws that require one or more of these things, but here in Georgia, we don't have those state laws. So the FLSA is the only law that would apply here. Now, nothing prevents you from offering any of these benefits to your employees, and certainly employers, including nonprofit employers, may want to incentivize employees by offering them vacation or PTO or by giving them extra pay if they have to work on a holiday. But it's not something that is required by the FLSA. So after hearing about all of the rules you have to follow when you have employees who are covered by the FLSA, it may seem like a pretty good idea to just dispose with employees altogether and just have independent contractors or volunteers or interns do the work. You just avoid all the hassle of having to comply with all these complicated overtime rules and worry about overtime and other employment laws. Well, that may sound like a good idea, and there are certainly advantages to having non-employees perform work for you. But the problem is that even if an organization decides that it wants to treat a worker as, let's say, an independent contractor or a volunteer, the law will look past what the employer wants to do and look at the actual relationship between the worker and the organization. And the law will say, what is the real legal relationship between these parties? So, for example, some questions that come up all the time in this area are, how much control does the organization have over the worker? How is the worker paid? Is the worker really an employee, or has the worker been misclassified? You can't just label someone an independent contractor or a volunteer and be done with it. You have to make sure that the person is properly classified according to the appropriate legal test. And if it turns out that the worker is misclassified, if they should have been classified as an employee, but you have been classified in some other category, the consequences could be quite severe, as shown here on the slide. You can end up owing back taxes, back pay, unpaid overtime, fines and penalties. Also, another thing that a lot of companies may not consider is that non-employees are typically not covered by workers' compensation insurance. Well, what does that mean? It means if they get hurt and they don't have insurance, or if they do have insurance, they can sue you in a tort lawsuit as opposed to filing a workers' compensation claim. And so it's actually more costly to have workers who aren't covered by workers' comp. Okay, so the next slide, independent contractors. There are many different tests for analyzing whether a worker should be classified as an independent contractor or an employee, and the tests depend on which lens you're looking through. So if you look at the relationship through the lens of the FLSA, there's one test that applies. If you look at the relationship through the lens of, say, the Internal Revenue Code, the IRS has its own test. There's a separate test for workers' compensation, unemployment. And it's even possible, as confusing as it sounds, it's even possible that an employee could be properly classified under one test and misclassified under another test, which is all the more reason you need to have an attorney walk you through these things. But what it all comes down to is essentially how much control the organization is either exercising or has the right to exercise over the worker. That's the first bullet that we put here on the slide, the degree of control, right? And really the distinction, if I had to boil it down to a single sentence, the distinction between an employee and a contractor is that an employee has to comply with the employer's rules about how to perform the job. Whereas with an independent contractor, the contractor just has to deliver the end result. So the more the employer is getting into how do you do this job, what rules have to be followed to get from point A to point B, the more likely it is that person will be viewed as an employee and not a contractor. You think about someone you hire to paint your house who's a contractor, you just tell the person what day to show up, what color you want the house painted, and you come back and it's done. You're probably not going to get into how the person goes about setting up the work site, how many workers they hire, whether they use a paint roller or a brush. If you do, that makes it look more like the individual as an employee and not a genuine independent contractor. Volunteers are the next category of alternative workers that you often see in the nonprofit world. And if I have to give you a definition of volunteer, it's very simple. A volunteer is someone who works for free. They work without any compensation or any expectation of compensation. Now, everyone knows that volunteers sometimes receive expense reimbursement, and that's fine. And it's also fine if they receive a small stipend, but the concept behind a stipend is that it is not wages, it's not compensation for services rendered. It's a small amount to cover whatever sort of out-of-pocket costs that the person incurs. And the DOL has a rule of thumb that it uses, which is you shouldn't pay a stipend that's more than 20% of what you would pay an employee to perform the same task. If you do pay a volunteer a stipend of some sort, if it is more than $600 in a calendar year, you have to report it to the IRS, and you should report it on a 1099, not a W-2. W-2s are for employees, so don't do that. A couple of things to keep in mind. So it may be tempting when you're faced with the changes in the FLSA regulations and you're facing increasing overtime costs. It may be tempting to have employees, or employees may even of their own volition say, you know what, I will volunteer to do some of this work, and you don't need to pay me for it. I just want to contribute to the organization. Well, guess what? That's a good way to get into hot water with the DOL. And if you have an employee that you have a falling out with at some point, and all it takes is one, you're looking at a potential FLSA claim or collective action. Don't ever have employees volunteer to perform the same job duties or even similar job duties that they're paid to perform as employees. And the same reasoning applies to the second point here, which is you should never direct employees to perform volunteer work during their regular working hours, even if the duties are different. Because under either scenario, it looks like off-the-clock work. That's how a DOL investigator is going to see this. It looks like you are simply having the employee do work and not pay them for it. Finally, interns. The third category of alternative workers, interns. The Department of Labor uses 6 factors shown here on the slide to gauge whether interns are properly classified. And if these 6 factors are not met, then the intern will be deemed an employee. So it's the same situation as with volunteers and independent contractors. If the test is not satisfied, the individual is misclassified, and you can end up owing all kinds of back pay and unpaid overtime, taxes and penalties, etc. So the takeaway is if you rely on independent contractors, volunteers, or interns, you really ought to consult with an attorney, or at least reach out to the Pro Bono Partnership here in Atlanta for guidance to make sure you're doing everything you can to structure that relationship in a way that you can avoid as much as possible any risk of misclassification claims. So with that, we're now free to take any questions that anyone has.
One question to start with Scott, and you repeat it.
Sure.
I appreciate it. The question is, are you required to reimburse
So the question is, are you required to reimburse employees for meals that are eaten during a training session? And the answer, as far as the FLSA is concerned, is no. You're not required to reimburse employees for meals. Are there any other questions?
I do have a question about the, not the fluctuating workweek, but the third example that you about hourly non-exempt, where you calculate the base rate based on the hours that the employee is working. And my question is, in that scenario, you need to have an agreement with the employee about what their base hours are going to be, just so you would for fluctuating workweek.
I think it's always wise to have, I'm sorry, so the question is, when you have an employee who is, the third example that we gave earlier, you have an employee who is paid a base hourly rate of pay that is calculated based on the number of hours that they're working each week. You have to have an agreement with the employee in terms of what their base hourly pay is going to be and how many hours they're going to be working. And the answer, I think it would be certainly recommended that in any situation you have a very clear understanding with employees in writing as to what their hours are going to be and what their base hourly rate is going to be. And in fact, part of the FLSA's record keeping requirements is that you keep records of the employees' hours worked, their starting and stop time, and how their overtime pay is calculated, including what the base hourly rate is. So yes.
Another question. What if you have a contractor who's paid for performing on specific projects, but they volunteered on other projects without pay?
The question is, if you have a contractor who is paid for specific projects but volunteers on other projects, is that okay? Well, assuming that the contractor is legitimately classified as a contractor, then the risk that you may incur from having that person volunteer on other projects is really, you don't have a risk from an FLSA standpoint, because the question is whether the person is properly classified. The contractor is unlike an employee, so that, as opposed to if you had an employee who was volunteering to do other work, that would raise the concerns that I mentioned earlier about having an employee do work for you off the clock. The contractor is not in the same situation. The contractor could perform work on a volunteer basis, and again, assuming that the parties are properly classified, you don't have any risk of misclassification or having to owe the contractor unpaid compensation or overtime or anything like that. The question is, if you have an employee who is being sent home early, so this is the flex time concept, employee is, or maybe not even flex time, employee has worked their full weekly schedule, but then goes home, and you want to make sure that employee isn't performing work after hours, like checking emails and logging into the computer and doing work. Is it important to put this in writing? And the answer to that is yes, because you want to demonstrate that you are taking steps to make sure that employees are not suffered or permitted to work when they're not on the clock. So I think it would be formal. It could be a simple email, Lori, as a reminder, you're not to log into the Pro Bono Partnerships computer system or check emails after hours, and leave it at that. And I would add to that too, sometimes employees don't obey, right? They end up working after hours anyways. And in that situation, I have clients come to me all the time and say, well, do we have to pay it? I told Lori not to work and she worked anyways. And the answer to that is yes, you still have to pay under the Fair Labor Standards Act. It is still compensable time. Now, doesn't mean you can't write Lori up and you should have a policy that says overtime should not be worked without prior authorization of a supervisor. And if the employee disregards that directive or disregards that policy, then he or she is subject to discipline, but you still have to pay. Sure. So the interim requirement. Yeah, and we didn't go over them in detail, but basically, the key thing with an intern is, first of all, there ought to be some type of educational or academic program that is behind this. So sometimes I've done some work with pro bono clients over the years that have workers they call interns, and I start asking, well, is the person getting credit at Georgia State or something else? And well, no, they're out of school. Well, that's a red flag. The idea behind an internship is that the internship experience is similar to the training that's provided in an educational environment. So typically, an internship that would not raise red flags from a DOL investigator standpoint would be an internship where it is tied to an academic program, and perhaps the employee is getting some type of work credit, academic credit for participating. The intern is the primary beneficiary of the internship, is the second requirement. So think about it this way. We at King & Spalding have summer associates, and these are law students, typically in their second year of law school, that will spend a summer working at King & Spalding and sort of shadowing attorneys around. And I always say that, think about it this way, if they're kind of getting in the way, right? You have to take them around and have all kinds of fun summer associate events and find, work for them to do. Write me this research memo. And typically, you may get a little bit of useful work out of them, but by and large, the intern, the summer associate, gets more out of it than you do. That's how an internship should work as far as the DOL is concerned. They're not there to replace employees and do work that you would normally have to pay someone to do. They are there to gain experience that they can then use in their future career. So that's the third requirement here, is they're not displaced. They're not there to displace employees. They actually work under the close supervision of other employees. And number 4, the employer derives no immediate advantage. In fact, the internship may impede operations. So again, using my example of summer associates, if I have to tow around 3 or 4 summer associates to my depositions and client meetings, they're kind of getting in the way. They're impeding operations. It's not that they're really doing any productive work for me. Number 5, they're not necessarily entitled to a job when the internship ends. So if you're using the internship program as nothing more than like a training, field training week for your training camp for your future employees, then that will raise red flags. Doesn't mean that you wouldn't offer a job to an intern. I mean, often that's how you get your foot in the door, is you get an internship and you hopefully impress the company enough to offer you a job. But if this is just a training system under another name, then you probably ought to be paying those people. And then finally, the last thing is that the employer and the intern understanding internship is unpaid. Now, you could have a paid internship. That's different. But assuming that we're talking about an unpaid internship, there has to be a clear understanding, and it should be in writing. In fact, I would advocate that you have a internship agreement with the intern that lays all this out, and they acknowledge and agree that they're not going to be paid for the time that they spend as an intern. Yeah, essentially, yeah. I mean, so sometimes when I've had clients that have sort of refer to interns as interns, and it turns out they're not really interns. Oftentimes, they may be properly classified as volunteers. Can a nonprofit organization continue to pay comp time to employees? The answer is no. You should not be paying comp time. You should be paying comp time now, so you shouldn't be doing it in the future. So I would stop doing that immediately, and just tell employees going forward this is how you be paid. So if you want further information on that, then feel free to reach out to the Pro Bono Partnership, and they'll be happy to guide you. All right, well, thank you, everyone. I hope you've enjoyed the presentation this morning, and hope you got a lot out of it. And have a wonderful week.